Disputes related to copyright, trademarks, geographical indications and undisclosed information in WTO. As in our past discussion, we have seen that there are cases related to patent, and most of these cases were especially in the pharmaceutical and agricultural chemical product sector. But this discussion is different from the past, because here we are highlighting the cases related to copyrights, trademarks, geographical indications and undisclosed informations in WTO. So, these are the number of cases DS 28, DS 42, 82, which you can find out in detail on the WTO website also. And we are going to discuss these cases one by one, especially related to the copyright. The first case, which is the DS 28 between Japan and United States, and this is a very old case, 1996 case, where the United States complained that Japan's copyright regime for the protection of intellectual property, especially in the sound recording sector, were not consistent with TRIPS Article 3, 4, 14, 61, 65 and 70. So, this matter was also settled on 24th January 1997, and we have seen that we can see here that within 1 year almost they were able to resolve this issue. The second case is DS 42, where the Japan and European communities were having the disputes, and the European Union complained against Japan for measures concerning sound recording for violating IP protection of sound recording under GATT Article 22.1, violation of Article 14.6 and 72.2 of the GATT of the TRIPS agreement, and this issue was also mutually agreed and found the solution. In case of the case DS 82, Israel and United States, this was also the case of 1997, where the US has complained against Israel in respect to the Ireland's for measures affecting the grant of copyright and neighboring rights. Ireland violated Articles 9 to 14, 63, 65 and 70 of the TRIPS agreement, and dispute was also agreed in 2000. In case of case DS 83, Denmark and United States, where the Denmark was the respondent, the United States complained against Denmark for measures affecting the enforcement of intellectual property rights, and Denmark had violated Articles 50, 63 and 65 of TRIPS agreement, and dispute was again mutually agreed on 7th June 2001. In case of the case DS 86, Sweden and United States, the United States complained against Sweden for measures affecting the enforcement of intellectual property rights, and Sweden had violated Article 50, 63 and 65 of the TRIPS agreement. Both the parties had agreed. The case DS 115, United States European Community, the United States complained against ES for measures affecting enforcement of intellectual property rights and grant of copyright and neighboring rights. Neighboring rights are basically the copyright and related rights, and that is why it is called neighboring rights. So, copyright and neighboring rights, and European Commission had violated Articles 50, 63 and 65 of the TRIPS agreement, and this dispute was also agreed on November 2000. One of the major case related to the European communities and United States was the US complained against the US for the lack of information of IPR in Greece. The US claimed that significant number of television stations in Greece regularly broadcasting the copyrighted motion pictures and TV programs without having the authority from the copyright owner. The US contended that effective remedies against copyright infringement do not appear to be provided or enforced in Greece in respect of these broadcasting. Measures violated were Article 41 and 61 of the TRIPS dispute agreement, which was mutually agreed on 20th of March 2001. Again this DS 125 case is between United States and Greece, and the matter was same as it was in the DS 124. So, the case DS 160 related to between United States and European communities, where the US was the respondent. The US complained against the United States in respect, European Commission complained against United States in respect of section 110 of 5 of the US Copyright Act. The European Commission contended that section permits playing of radio and television music in the public places without the payment of a royalty fee. The European Commission considered this inconsistent with US obligation under Article 9(1) of the TRIPS agreement. On 23rd June 2003, the United States and the European communities informed the dispute settlement body for a mutually satisfactory temporary agreement. The next case is the DS 362 case between United States and China, more recent case where the US complained China for the measures pertaining to protection and enforcement of intellectual property rights in China. The measures were again inconsistent with Article 9.1 of TRIPS agreement. Copyright Argentina, the European communities, Japan, Mexico and Chinese Taipei reserved their third party rights, and subsequently Australia, Brazil, Canada, India, Korea, Thailand were the third party. Disputes related to trademark. We can see here that around 9 disputes were related to trademarks between Indonesia and United States as DS 59, European communities and United States as dispute 174, United States and European communities as a part of dispute 176, China and United States dispute 362 case, DS 434 Australia versus Ukraine, and other cases are between Australia and Honduras, DS 435, DS 441 Australia versus Dominican Republic, again Australia versus Cuba, DS 458 and DS 467 Australia versus Indonesia. So, the first case, the DS 59 United States and Indonesia, the US complained against Indonesia for Indonesia's national car program, and Indonesia has violated exemption from the custom duty and luxury taxes on imports of national vehicles and components under Article 1 and 3 of the GATT 1994, Article 2 of the TRIPS agreement, Article 3, 6 and 28 of the SCM agreement, and Article 3, 20 and 65 of the TRIPS agreement. So, Indonesia adopted a new automotive policy on 24th June 1999. For more detail, you can just find this case available on the dispute settlement body. And the case related to United States and European communities, where the United States complained against the US for the alleged lack of protection of trademarks and geographical indication for agriculture products and foodstuff. The US considered this situation to be inconsistent with the European community's obligations under the TRIPS agreement, including but not necessarily limited to Article 3, Article 16, Article 24, Article 63 and Article 65 of the TRIPS agreement. Again this case, European communities and United States, between these two are the case where the US complained against the US in respect of the section 211 of the US Omnibus Appropriation Act. The European Commission alleged that section 211 did not allow registration or renewal in US of a trademark. The section was not in conformity with the US obligations under the TRIPS agreement, Article 2, 2.1, 3, 3.1, 4, 15, 16, 16.1, 17, 18, 19, 20, 21, 41, 42 and 62. The dispute was mutually agreed on 17th December 2004. And the next case is the case between United States and China, DS 362 case, where the US complained China for measures pertaining to protection and enforcement of intellectual property rights in China. The measures were again inconsistent with Article 9.1 of the TRIPS agreement. The copyright, Argentina and the European communities, Japan, Mexico and Chinese type I reserved their third party rights. The Ukraine complained against Australia as a part of the DS 434 case, where for the same Australian laws and regulations were imposed restrictions on the trademarks and other plain packaging requirements to tobacco products and packaging. Ukraine claimed that Australia's measures appeared to be inconsistent with Australia's obligations under Article 1.1, 2.1, 3.1, 15 and so many other articles as per the TRIPS agreement. Apart from this, the Trade Barrier Agreement and Article 1 and 13.4 of the GATT 1994. So, and the next case is the Australia versus Honduras, where the Honduras complained against Australia for some Australian laws and regulations which imposed restrictions on trademarks, geographical indication and other plain packaging requirements on tobacco products and packaging. Honduras claimed that Australia's measures appeared to be inconsistent with Australia's obligations under 2.1, 3.1, 15.4, 16.1, 16.3, 20, 20.2b, 20.24.3 of the TRIPS agreement and Article 2.2 of the TBT agreement and Article 3.4 of the GATT 1994 agreement. So, the Dominican Republic and Australia, the case which is the DS 441 case, 2012 case, where the Dominican Republic complained against Australia for some Australian laws and regulations which imposed restrictions on trademark and again plain packing requirements on tobacco products. Various articles 2.1, 3.1, 15.4, 16.1, 20, 20.2b and 20.43 of the TRIPS agreement were again cited as the case of inconsistency as per the Australia's obligation under the TRIPS agreement. Apart from that, the TBT agreement and Article 3.4 of the GATT 1994 were also cited for this inconsistency. The DS 458 case, where the Cuba and Australia were the two parties, Cuba complained against Australia for some Australian laws and regulations which imposed restrictions on trademark and other plain packing requirements on tobacco products. And most of the similarities of the violation of the articles of TRIPS we are finding here, 3.1 in the previous case, 15.4 and 16.1, 20 and 22b, as it was also the case of the previous case and also 24.3 of the TRIPS agreement. One more case is the Australia and Indonesia, where these two parties were having the disputes. Indonesia complained against Australia for some Australian laws and regulations which again imposed restrictions on trademarks and GI, and Indonesia claimed that Australia's measures appeared to be inconsistent with Australia's obligations under majority of the TRIPS agreement, which were highlighted by the previous cases also in trademarks, especially Article 2.1, 3.1, 15.4, 16.1, 16.3, 20 and 22.2b and 24.3 of the TRIPS agreement. So, disputes related to GI. There are certain disputes related to geographical indications. These are the list of the cases: DS 290, DS 441, DS 458, DS 467. So, in one of the case where Australia and European communities had the conflict, and Australia's complained against the European communities for measures related to protection of trademarks and GI for agriculture products and foodstuff. And we find that there are large number of articles cited here for the inconsistency as per the as per the European Community's commitment for the TRIPS agreement. So, article 1, 2, 3, 4, 10, 16, 20, large number of cases 22, 22.2, 24, 24.5, 41, 42, 63, 63.1, 63.3, 65 and 65.1 of the TRIPS agreement were found inconsistent with the European Community's obligations under the TRIPS agreement. So, there is a need to look into all these articles from the available link, which will give you the idea that how these articles were the part of the inconsistency in this particular case and also in some other cases. So, it is indeed important for all the participants in this course to really have a look on these cases and these articles, because without understanding these articles it is really important to find that why there is a conflict. So, in case of a new case, that is the DS 441 case, where the Dominican Republic and Australia had they were the two party. Dominican Republic complained against Australia for some Australian laws and regulations which imposed restrictions on trademark, GI and other plain packaging requirements on tobacco products and packaging. So, we find that almost all previous cases, especially on tobacco issue, is violating the similar articles, that is 2.1, 3.1, 15.4, 16.1, 20, 20.2b and 24.3 of the TRIPS agreement. Again, we find here the case related to Cuba and Australia, where the Cuba demanded deliberation with Australia related to certain Australian laws and regulations that supposed to unnecessarily impose on tobacco products trademark restrictions and other plain packaging packaging requirements. Cuba claimed that these measures are inconsistent with TRIPS Act 3.1, 15.4, 16.1, 20, 22.2b, 24.3 and other GATT articles 3.4 and technical barriers to trade. The next case is the DS 467 between Australia and Indonesia, where Indonesia demanded deliberation with Australia related to certain Australian laws and regulations that supposed to unnecessarily imposed on tobacco. So, with Australia we find that the majority of the countries, whether it is Cuba or Indonesia or in previous cases also the European Union or Dominican Republic are fighting for, they were really highlighted the violation of various commitment of Australia as per the TRIPS agreement, and this shows that especially in tobacco sector this particular cases related to Australia is showing that a huge violation of different TRIPS agreement were the part of the Australian strategy, deliberate strategy, and due to the involvement of the member countries only now these cases are filed in the dispute settlement body. So, dispute related to disclosed information, this is the case between the China and European communities. In this case we find that the European communities appealed decisions with China on March 2008 for the measures influencing financial information services and foreign financial information services suppliers in China as claimed by the European communities. The European communities believed the following provisions are inconsistent with Chinese obligations, and these are GATT's article 16.2, also the TRIPS agreement of article 39.2 and China's protocol of association of the WTO is responding to this particular case. There are other cases where Brazil and European Union and India and European Union are the parties. In case of Brazil, Brazil complained that European Union for the siege of generic drugs in transit. It said that that many European Union and Dutch measures were inconsistent with the obligations of the European Union, and the Netherlands under Article 5 and 6 of the GATT 1994 and various provisions of TRIPS agreement and articles of the WTO agreement, Canada, Ecuador, India, China, Japan and Turkey were the third party, and European Union later accepted that request of Canada, China, India, Japan and Turkey to join the consultations. So, in second case, DS 408 case, the US complained against United States for section 337 of the US Tariff Act and related rules of practice and procedures of the International Trade Commission quotation content in chapter 3 of title 19 of the US Code of Federal Regulations. And the US alleged that those measures were violated article 3 of the GATT 1994 and TRIPS agreement article 2 and article 2 Paris Conventions. So, what message is coming from these cases? These cases at dispute settlement body proves the importance of intellectual property rights across the world. We are finding that whether it is Cuba or whether it is Australia, whether it is Honduras or whether it is India, there are a large number of developing, least developed countries, and developed countries are involved in various disputes related to trademark, related to copyright, related to geographical indications and undisclosed information. So, the members have really tried to highlight the inconsistency and its resolution as per the TRIPS agreement, but many complex issues are still awaiting to be resolved, and this shows that the current phase of intellectual property rights and the protection of intellectual property rights is very important for the government, and so the government has to respond on behalf of the citizens or the firms in WTO that why certain articles were not followed, even if a single article is not really consistent with the obligations and the agreements signed by the country, then the country has to really work on, and they have to really make it consistent with the existing rules and law. So, the entire discussion on different disputes is giving us the idea that all these disputes are just because of the established agreement and rules which WTO has and the GATT has established 20 years before. Even after the establishment of dispute settlement body, countries are really not comfortable, and countries are really highlighting some of the cases, making it as a matter of disputes that certain violations are being progressed in copyright sector, in trademark, in patent, in undisclosed informations, geographical indications, and there is a need to really look into the acceptability of these acts and the necessity of the implementing these agreements on grassroots, and we find that dispute settlement body provides an opportunity for any country to prove that there is a discrimination and there is unjust on the ground of intellectual property rights, and developed or developing country or least developed countries, anyone is now exposed to answer all these questions to the world community. Thank you.